To be with us today. We are being recorded now or live streamed. And I do want to take a minute before we start our business to just remind you of our conflicts of interest policy. And if you have any conflicts, if you would please advise us of those before we participate in any matter that comes before the subcommittee. I do think it would be nice for us just to take a minute to introduce ourselves. All of us weren't on the call last time, so just to make sure everybody knows each other. So I'm Ashley Campbell, and I'm at Legal Aid of North Carolina, and I'm a state bar counselor from the 10th Judicial District. Why don't we go to Evan? Good morning.
Now I'm unmuted. Yeah, I'm Evan Rawls. I'm the state bar counselor from the 26th District, Charlotte.
Thanks, Evan. Daryl? You're muted, Daryl.
There we go. I'm Daryl Davidson. I'm from the 30th District, Iredell County and Alexander County.
Thanks. Catherine?
Good morning, everyone. I'm the State Bar Counsel. I'm very happy that this committee has been formed and y'all are studying this.
Yeah,
it's a big issue. I appreciate all of your contributions to this.
Thank you. Dion?
Hi, I'm Dion. I'm from the 13th District, and I missed the last meeting, so I'm sorry. I'll be happy to play catch up, but I'm glad I got to meet this one.
We're glad you're here. Savannah?
Hey, I'm Savannah Perry. I'm a deputy counsel in the Office of Counsel.
And everybody may remember that Savannah did that really great succession planning overview at the meeting, which I thought was really terrific. So thank you for that. And those materials are included with the agenda that Brian sent around. Barry?
Okay, there's sorry that I disappeared there shortly for a while, but I'm Barry McNeil, Deputy Counsel, and staffing the subcommittee. So I enjoy doing that.
Thanks, Barry. And we'll go to Brian, and then we'll end with Marcy.
All right, I'm Brian Oaten. I'm the Ethics Counsel and staff to this subcommittee.
And I know Marcy may have been driving, so she may not be able to unmute. But I think you all know Marcy. So she is our current state bar president. Marcy, thank you for being here. So we are gathered together to talk about succession planning, just as a reminder, and Dion, to get you up to speed. So, well, and I'll ask you, Dion, were you able to attend by any chance the succession planning for lawyers presentation that Savannah did at the state bar meeting?
No, I'm
okay.
Second strike, but
okay, no, that's okay. I don't want to put you on the spot. That was simply to sort of get a sense of what you may or may not know about the issue. So I'll just spend, 60 seconds sort of recapping what we talked about at our last meeting and why we've been formed. So there is currently not any type of requirement by our state bar that a law firm or a lawyer have a succession plan for his or her practice. And what that leads to is that, if a lawyer passes away or we can't find the lawyer, there is no plan in place sometimes for who is to handle that lawyer's cases and to sort of run off their business. And, if they're in a larger law firm, oftentimes their law partners will sort of step up and handle that. But this really can become a more significant issue when you've got a solo or a small firm practitioner, and there's just no one there to take over. So, State Bar leadership has asked us to look at the issue and maybe make some recommendations about what we can do to either implement, a requirement or to encourage lawyers to do succession planning and to make some type of plan. And I think, what we talked about at the last meeting was the preference is to encourage rather than compel, but that decision, hasn't been made yet. We need to talk more about today and what direction we would like to move. Brian did give us an overview of some succession planning issues at the last meeting. And then I know that some of us did attend that CLE. And, my biggest takeaway was that photograph that Fred Morlock put up on the screen. If you guys saw it, you won't forget it, of, what a desk looked like in a lawyer's office when he had to come in and be the successor, and sort of the challenges that successors face when there's not a plan and there's not a lot of organization. And how do you even figure out who the clients are for the lawyer, much less sort of start closing down their practice. So the first order of business today is to approve the minutes from the April 6th meeting. Those were attached to your agenda. I will entertain a motion to approve those if you're ready to do that.
I'll make a motion. We approve the
Okay, is
minutes.
there a second?
I second it.
Thank you, Evan. And any discussion or any modifications or amendments needed to the minutes? Okay, all in favor of a motion to approve those?
Aye.
Thank you. So now we're going to turn to Brian. He's going to sort of do a recap in more detail than I just did, I think, of the different approaches and some pros and cons.
Right. And Ashley, before we get to that, I see Marcy has raised her hand. So Marcy.
Oh, I thought she was voting. I thought Marcy was voting.
No, I'm not voting. Can you hear me?
We can.
Okay, I could not. You're right, Ashley. A while ago, I was not in a position to say good morning, everybody. I just want to say good morning to everybody and to thank you for your work on this committee. I consider this a very, very important issue. I know Dion does as well, that she was called in sort of to help out with a solo practitioner in Johnston County who should not have died way too soon. She was in her 50s and died from a heart attack. And so, yeah, this is a very important issue. And I just want to thank you.
Thank you, Marcy.
All right. Well, I'll provide, like we said, or like Ashley just alluded to, a bit of a detailed recap of where this conversation is, where we left off, and kind of what the intent of today's meeting is. Basically, we were talking about the different options that we have for succession planning. We all recognize that, yes, the rules of professional conduct call attention to lawyers need to potentially plan for their unavailability. Rule 1.3, the comments to 1.3 talk about a lawyer's duty of diligence and how that duty of diligence encompasses the need to be ready if you're unavailable to get your clients basically off to new representation. It is an aspirational comment. There is no enforcement of this encouragement. And so we looked at other states in the last meeting that have done something. You see a variety of different approaches. There are some of those mandatory approaches. A handful of states require lawyers to actually put somebody in the position of what we'll call a successor attorney. Although I will just kind of say successor attorney, I feel like maybe we can find a better term, because sometimes successor might imply that the person is stepping into the actual shoes of the lawyer to represent the clients, and that isn't exactly what we need. That gets a little more nuanced, but nevertheless, I'm still going to use that term because it's so commonly used. But yes, there's the mandatory states: Iowa, Florida, Maine, Michigan, New Mexico is the most recent state to adopt a mandatory rule. But then there's some states that have a voluntary option. They provide the opportunity for their members to designate somebody. And really, that somebody, this successor attorney, is really supposed to be the person that kind of knows where everything is in the garage. They have the keys to the house, and they know where the files are located. Where are if the lawyer has saved their password somewhere, where are those passwords? Where are the bank accounts located? They might not have all the records, but they're aware that the person has a trust account at First Citizens or whatever it may be. And then there's some other states that really put more emphasis on education. They have maybe there's sample documents that lawyers can execute between themselves to authorize another lawyer to serve as their quote unquote successor. There may be a handbook for lawyers or a CLE program that's offered by different states to really educate lawyers on the need for some type of succession plan and how you go about that, because winding down your practice or preparing to not go to your practice, even when it's an unplanned absence, is a large task. There are a lot of things to take care of. And like we saw in that picture from Savannah's presentation, many lawyers, I think I was struck by Savannah's question at the beginning of her presentation, when she said, how many folks if you didn't go into your office tomorrow or didn't go in all next week, how many folks have an office in such a shape that another lawyer could step in and know exactly where you left off? Show of hands, and I didn't see many hands go up. So it's that thing of, when you have this mountain to tackle in creating some sort of plan, it feels overwhelming. And these educational resources, some of which are in your materials, the very last page of the PDF packet that you were sent has links to some of these different handbooks that other states have put out there for your reading, for your kind of consideration of, how do you tackle this? But, things like a sample document that allows you to write down who are your active clients, where are your client files, what's your organizational method, is there a color coding, things of that nature. And maybe even if you don't do that, reading through this booklet might make you think, you know what, I should do a color coding. I should make the red files are going to be the real estate files and the yellow ones are the family law, or whatever it may be. So educational opportunities are there. I think there can be a combination of these different efforts, but particularly I wanted to give you all a bit of an update or a report on a couple of things. One was as to the voluntary states. I actually reached out to Georgia, our closest state that has this voluntary opportunity. I reached out to them and asked them, what's been the response to your voluntary opportunities that you've been offering to lawyers? And the response I got was that it's been moderately successful. They didn't have a percentage of how many lawyers have actually taken advantage of the opportunity to designate someone, but they said that a large number have. They have not been able to kind of get it to catch fire. They say they put a reminder and give the opportunity for everyone's annual registration, their annual dues. They make it kind of, front and center. So you have to actually click past it and intentionally ignore it if you're not going to do it. But it's right there. And they have had a number of lawyers actually take advantage of that. Of course, the folks, when I asked them, what would you expect of a lawyer that's named as a successor, they basically described our trustee process. This person is tasked with going into the practice and sorting things out to see, do they need to notify the courts? And if so, which courts do they need to notify that, this attorney is now unavailable and the client may need a continuance or whatever it may be. But notifying the courts, notifying the clients, and arranging to get that client file to the client so they can move on to their subsequent representation. I asked them some of those more nuanced questions of, well, what about confidentiality? Is there that's one thing that we run into with our trustee process. Lawyers are, stepping in and looking at confidential client information, and they are not authorized to do that. That's where the court order comes in. When we have a court that appoints a trustee, they put themselves in the position or empower them to actually look at this confidential information. And he said that they have some rules, kind of, it sounds like administrative rules, that permit a lawyer to step in, still be bound by the duty of confidentiality, but it basically kind of preemptively takes care of that concern and authorizes the lawyer to do this task for the benefit of those clients, while also being aware of any potential conflicts or sensitive issues like that. So it was an interesting sort of conversation. He did say that one of the things they thought of when they first put this in place was that they expected at some point it was going to become mandatory. They started with voluntary and they expected that it would become mandatory for everyone, but they weren't sure if or when that was going to take place, because it's kind of it's been a steady process, but it has not caught fire. And they're still trying to consider, is it really appropriate to do something that's mandatory for everybody? Like every lawyer that's in a big firm in Atlanta, do they all need succession plans, each and every one of them, when the firms probably have their own succession plans? We talked about before that this really comes into play for solos and small firms. And that was one point that he made, that this is really important for small firms in Georgia, as we talked about at our last meeting, because you have firms, maybe there's 3 partners, but they all do something different. And so just relying upon your partner who has a completely different practice area to wind down your estate practice may not be the best thing for your clients. You may need to name a peer that actually is familiar with your area of law, things of that nature. So he stressed that small firms definitely should be included in the conversation. But that question of when you get to larger firms, is it really something that's necessary and therefore required? Is kind of a tougher question. And so I guess with that said, I want to kind of highlight the questions that Ashley had asked us at the end, if that's all right. And maybe let me pause because I know I've been saying a lot of words here. Does anybody have any questions about the Georgia conversation or anything that I've said so far before I get to Ashley's 2 questions that she posed to Alice and I at the end of our last meeting? Okay, seeing that I'm just riveting everybody with this report, let me go on. So Ashley had asked Alice and I to look into 2 issues, one being whether we would actually save resources if we created a mandatory reporting process.
And Brian, can I
yes.
make a comment there, just because I know that some people may not know this? I just want to, so the state, when there is no successor and the state bar has to assist in this process and have a judge appoint a successor, which is I think what we're calling the state bar, then has to compensate the successor. And my recollection was it was like $80,000 last year or something like that. Brian can tell me if that's wrong, maybe less. But so there is some money that the state bar is currently having to spend for practices that don't have a plan. Okay, and because Brian, that's going to lead into you answering the question.
Yeah, and I think Savannah probably had, I know Savannah had the specific numbers for each year, and it does vary. I feel like on average, Savannah, please correct me if I'm wrong, because I'm going to go off of memory here, but we have something like, say, between 20 and 25 trustees that get appointed through this process. The state bar approaching the senior resident superior court judge and asking somebody to appoint somebody to wind down the practice. And we spend on average, was it 40,000, between 40 and 50,000 a year? I don't know if I'm right or wrong there, Savannah. Am I high or low?
It looks like it's right around 40 to 50. Yeah, some years are lower. 2022 was only 20,000.
Okay.
But these figures are actually, when the state bar is asked to pay, we are the last resort for payment. We don't want these trustees to go without pay for the service that they're providing. They're paid at $75 an hour. But there's an administrative or a statute that says that trusteeship fees and expenses are actually an administrative expense of a deceased attorney's estate. So that's the first place we want these trustees to look for payment.
Right. No, thank you for that. Yeah. And so that was this question that we had of, well, we're spending so much resources on this trustee process. And one of the largest burdens that we deal with is finding a trustee in the first place. And we spend a lot of staff time. That's, a little bit more difficult to calculate there, as far as, when we're trying to find a trustee in a particular district that's willing to step into this role, which can be a significant role, especially if it's somebody in the community that knows, I know that person's practice and it was a mess. I've been to their office. I don't want to do that. Then it can be a real burden on staff time to try to find somebody, not to mention trying to actually sort everything out. And so the question was kind of, well, what if we made this mandatory? And basically the state bar did not have to hunt people down. So we're saving on staff resources, but we're also hopefully kind of forging a relationship between lawyer and this trustee or successor, whatever we're going to call them, such that they're aware of the office. Hopefully they can be more efficient in the wind down. And the thing that Alice and I looked at in answering this question, which we ultimately kind of came out thinking, I don't think it's going to save that much resources, if at all. If anything, it might be actually more burdensome to enforce a mandatory rule on the 32,000 North Carolina lawyers that we have in our membership. Because when you have something that's mandatory, for one, you have to enforce it, right? And so to that end, when you're enforcing something that's mandatory, then you have potential show cause issues. You have a lot of other staff time that's spent enforcing the administrative rule. But the other thing is that even if we have a name, we have a starting point, we as the state bar still need to vet that person. And when I was talking with the folks in Georgia, they have experienced a number of times where somebody named someone and the person named had no idea that they were named. Now, all of their literature, all of their templates and so forth tell lawyers to communicate, If you're going to name somebody, talk to them before you name them so they're aware of this. But that doesn't always happen. And I think the state bar would still need to vet all these folks. We might save some time looking for the starting point, but if the starting point that we've been provided is not actually effective, and as like I said, Georgia has experienced that a fair amount, then we're still in the same position. But now we're also enforcing this mandatory thing. So Alice and I were ultimately kind of reaching the conclusion that I don't think it would necessarily save resources. If anything, it might cost us a bit more resources to make something mandatory. So before I move on to the other question about incentives, and I'll kind of give the intro there, I think maybe Ashley, if it's all right with you, this might be a good time to talk about the mandatory aspect of a succession plan. If anybody else has any other questions or thoughts that we should consider in this discussion. Everybody's all good? Okay. Well, seeing no other discussion. Oh, yes.
Ryan, I'm sorry. I was kind of waiting to see if anybody else spoke up because I really didn't want to do that until everybody else did. I think I may need more information, but I think I'm leaning towards making it not mandatory. And the reason is because you get so much pushback from everybody that thinks the state bar keeps putting more and more and more burdens on them, through CLE, through other stuff. So I mean, unless you can convince me otherwise, I think that voluntary would be good. And then I think it would be incumbent on our counselors and others to really get the message out there and to try to encourage people to do it. So those are just my initial thoughts.
Brian and Ashley, I agree with Marcy. I think judging from, your agenda, we're looking at, educational, then voluntary, and then mandatory. And I like Georgia's progression through this. And I think that we ought to really start with the educational side. And Marcy, I think you may need to write your quarterly missive in the Bar Journal and put the photo that we saw of, Fred Moreland's desk in that letter you write every quarter, but also to put the statistics into the letter. And also talk about perhaps the nature of the practice in solos and small practitioners, that that it's difficult, and lawyers will respond if it goes to their pocketbook. And I do think that if lawyers become aware that perhaps some client security funds will be used, which will cause increases in client security funds, maybe perhaps we ought to consider something like a client security fund that's called, for a better word, a successor security fund that funds this, that the practicing bar pays for. The mandatory enforcement, we've got lawyers that are dead, disbarred, disappeared. And so I don't know how you enforce a mandatory situation where the lawyers are really, really unavailable. And I'll give one example. We had a lawyer in Charlotte. His name was Lyle Yurko, and some of you know Lyle. He was a well-known figure in the criminal defense world, statewide and to some extent nationally. And he started developing some pretty severe degradation of his emotional and mental abilities. And I was close to Lyle. And so his staff started calling me to come help with sort of managing the office. And, one day I walked in and Lyle was at a table crying because he felt like he couldn't go to federal court. And I spent a couple of hours with him, basically going over his presentation and getting him ready. But he was seriously degraded at that point. And I spent the next month or two trying to convince him to let somebody come in and unwind his practice. And he resisted that, but he was a solo practitioner and had a very beefy criminal practice that spread from federal court here, federal court statewide, post-conviction, superior court state, district court state. And so he finally broke down, drove to the airport, left his car there, and flew to Vietnam and never came back. And it left everybody kind of holding the bag. The bar called me and asked me if I would take over as the trustee for his law firm. And because of my relationship and also I just didn't have the time to do it, I declined. But it showed once again that when lawyers are siloed, like a lot of lawyers are, if we're going to have a sort of a voluntary situation where we ask lawyers to, to perhaps volunteer in their areas of practice, in their geographic areas, to come in a situation like it was with Lyle. And Marcy, I think if you put it in your letter, the statistics speak for themselves. You can speak about Georgia. You can talk about, the problems of solo and small practice work, and talk about possibly voluntary compliance here. One of the things I was thinking about also is that the bar has had very successful results in the surveys that we have sent out in several of my subcommittees. We sent out a survey in the criminal justice survey. I'm trying to remember. I think we sent out a survey in PMBR, and I recall one other survey. And it's been very, very instructive to send out a survey. And if we can develop a survey to talk about successors, once again, I don't know, what the operative word is going to be, but I agree with Brian that perhaps we ought to figure out another word. It's, not the garbage man practice or the cleanup lawyer or, whatever. But, I do think a survey will help focus this as well if we develop it correctly and get it sent out to the bar. But I would advocate that we start educationally and with a survey, and in the survey perhaps ask open-ended questions about what recommendations do you have about mandatory requirements or voluntary requirements, and so I think there's a way to start this off and start on an educational side with an eye towards voluntary, and then pick it up from there rather than mandatory. Mandatory enforcement is going to be very difficult and expensive for the state bar, and I don't know if there's a way to to mitigate the expenses by perhaps adding another, or suggest to the bar that we're going to perhaps add another assessment that the bar does for this type of work. Because looking down the road, we are absolutely headed towards a large number of my generation of lawyers who are going to be dying, becoming disabled, hopefully not disbarred, but so we've got to look to the future, and mandatory is always on the table, and perhaps, like I say, we can make a list of a volunteer list with practice areas and geographic areas that might be willing to step in. But let's hold off on mandatory, but leave it out there, as a possibility that the rest of the bar sees. That's my 2 cents worth.
Evan, thank you. And Marcy has a question also, or a comment.
Hey, thanks, Evan. I agree with everything you said as well. I have already done my message for this next issue because you guys may not know this, but before you even leave the State Bar building after quarterly meetings, Jennifer is emailing you saying that your message is due by Thursday that week. So that's done. But I had already planned as my final message to talk about some of the initiatives and things that we're working on, and succession planning is definitely one of those. So that's a good idea. And I'll make sure that I include that in the last message. And I'm going to ask a stupid question. But does malpractice insurance, do they give you a break, or do they ask questions about whether or not you have succession planning? Because I guess you can't be sued for malpractice if you're deceased. Anyway, I don't know. I'm trying to think of all the incentives possible to get people to do it. But those are my comments. Thanks.
I can respond to that, Ashley, to the extent that I have a little bit of information just from talking with Lawyers Mutual before. I understand that they have a lot of resources that they offer, and they are encouraging folks to have that succession plan because there's, at least it's at the very least, it is potentially cleaning up a mess, or at least setting something up to clean up the mess when a lawyer becomes unavailable and say a client ends up missing a statute of limitations because there was no plan in place, then there may be some sort of claim. Now, whether or not it's viable, may be another question as far as malpractice against this attorney that passed away. But, if it gets brought against their estate, that's just something they don't want their insurers to have to deal with. And so they do encourage succession planning. And they have a number of resources. I think that's something, when we talk about educational opportunities, I think it's one thing that'd be a good step is understanding the full range of what is out there. The Bar Association has an ebook on winding down your practice. I know, like I said, Lawyers Mutual has a lot of different things that they offer their insureds to get the succession planning conversation started, if not fully executed. But I think there's other opportunities too. To your point, Eben, you were talking about PMBR. We are creating this cybersecurity module for folks to go through. I feel like the succession plan module, if we were to create one, would not be nearly as complex as the cybersecurity one. I think it'd be fairly quick to do if that's an option that this committee would want to explore, as well as just creating CLE opportunities. That's something that we give CLEs just as staff all the time, and this could be a topic that we could be a bit more intentional on. But again, there are some of those resources out there. They just may not be as prominent, frankly, because I think a lot of folks aren't. They don't want to think about this. It's something they know they need to do, but they just haven't done it, and it's not the priority. So we can put a spotlight on it. But yes, malpractice wise, they do offer resources there.
Yeah, let me just throw this in. This is a little bit off topic, but tomorrow morning, Leonore and I and Walter Brock have got sort of the final meeting with Lawyers Mutual, hoping that they'll come on board and sponsor a 3-year project with this PMBR cybersecurity project that we've been working on now for a couple of years. So everybody kind of keep your fingers crossed on that and hope that it comes through. We can pull it across the finish line.
I just wanted to make a comment. I can tell you, it absolutely scares me to death if something would have happened to me and nobody would know what's going on with my files. And I can tell you, I can walk up to the courthouse right now and poll about 4 or 5 lawyers, and they would not have any idea about what to do with a succession plan or winding it down. It's not something they think about. Nobody really thinks about it until a lawyer becomes disabled or they disappear or something to that effect. And so my question, just like what you said, is there a CLE course on it? Could there be a CLE course on it? Because, at the end of the day, I think it's too late when you can't come in the office anymore at that point or become incapacitated. And I almost think that it should be a required CLE at some point, to think about what would you do if you need to wind down your practice and how you would go about it. But nobody thinks about it. I mean, I think about it because I was a sole practitioner for 15 years. And I used to think if something happened to me and I was not even able to talk, where would, even just on the computer, where would they find information on the computer for my clients? So, I think it's a very important topic. And that's my cent and a half.
And Brian, I know you had a couple of other issues you were going to address quickly.
Yeah, I know one. Yeah, one question that you had asked, another one was just offering an incentive. What sort of incentives can we really explore? Could we offer CLE credit in this regard just for creating a succession plan? Generally speaking, the answer to that is that the CLE board has not historically approved, I guess, what you would call kind of like a self-study or work that you do on your own. And so that becomes a bit more difficult just for the act of creating a succession plan itself. And this was a similar question that we looked at for PMBR. And we could create checklists for folks to go through cybersecurity or any other topic and see if somebody basically affirms to the state bar that they completed this checklist, they went through this program on their own, perhaps they could get an hour of CLE. And I believe the CLE board, to that idea, reported back that no, they have not historically done that. And they weren't necessarily interested in that, but they could always continue the conversation. But I think the incentive still that is out there for voluntary, between the stuff, like if we created a CLE course, if there was something that whether it's through this PMBR module, maybe that's just a module in and of itself, and it gives you specific directions on where to log your trustee plan, or your named trustee, maybe if we want to call them that. That perhaps there can be some sort of just, again, pairing of an educational opportunity with the opportunity to designate. And I will tell you, just as far as the State Bar's membership portal, we have a new membership portal, we have a new database. It is significantly more capable than other databases that we have had. And from early conversations, it would not be difficult to create a new field, particularly in the annual dues registration process, just to have that be a part of, you go through, you pay your annual dues and ask the question, maybe just an introductory thing, a link to, what is a trustee? We can have this information on our website, and offer the opportunity for somebody to just put a name in there. Because again, the name is not an automatic, well, everything is done. A name is a starting point for the bar if we are called upon to actually do something. And so that could be something that can be added to our member portal. And I think, just to me, the incentive that when Alice and I were talking about it, it's really offering the ease of doing this, equipping people with the knowledge of what they should do, and so forth. The CLE credit itself, I think, would need to be attached to an actual CLE presentation, which is also a possibility and hopefully an attractive one. But I know the folks in Georgia, the person I was talking to said that his ideal, he has not been able to get it kind of worked out both, I guess, structurally and just technologically, but he was hoping to create a CLE that, to get your credit, your hour of credit, you had to not just watch it and learn from it, but you actually had to go in and designate somebody. That you only get the hour if you go in and you designate somebody. But creating that tie between everything, of course, it has proven to be a little bit difficult, and just in terms of how you actually program that. But still, that was his ideal. I think it's a curious idea. We would need to have a lot more stuff kind of set up before we even explored that. But still, I think we can be creative here.
And then, did you have any other? Is that it? Is that all the?
Those are all the questions.
Okay. Okay, great. So thank you for addressing all of those. And I know we've heard from some folks who think we should do focus on education and voluntary. Does anybody think we should do a mandatory program? I want to create space for that. If you want to share any thoughts about that.
You talking about a mandatory program for educational purposes or
for succession planning? So, a mandatory program would be a requirement that for purposes of licensure, that you have a succession plan. And then, of course, the state bar would have to police that. And so we've already heard from folks who think it should be voluntary, and that we should not have a mandatory program. So I just wanted to see, does anybody think we should have a mandatory program?
Well, actually, I think it would take a rule change, and we'd have to go through the, and Catherine Jean or who else would have to verify that. But it would have to go through the full process of rule changes, then publishing for comment, and then back to the full council, and then up to the Supreme Court for approval. But I think as I said before, I think this is just a little premature. I think that let's see what's out there. Let's see what responses we get from our educational efforts. Let's do a survey and see what response we get on the survey, and let's put on the survey that, what's your opinion about a mandatory rule change requiring it, and that way, I think the bar will sort of buy into this. If we impose this now on top, from above, I think the bar already chafes a little bit at some of the regulations and rules. And Brian, I think you probably get that, and Alice too. But I think the bar is still seen by a lot of lawyers as this, this super organization that just regulates and manages from above and does not get permission. But so let's ease into it. It's not off the table, and it's a thing that's probably, it'll be past my time as bar counselor, but it's probably going to be in the future.
Well, I just wanted you to respond to that, Evan. You'll be surprised to hear everybody loves our administrative requirements. I mean, we just get thank you cards. No, I'm kidding. I'm absolutely kidding. Nobody. But that was something that the person from Georgia said, I think, as he described it, with the voluntary to mandatory thought process, that again, they don't have any plan to make it mandatory at this moment, but that was the origin. He described it as, it'd be better to put the frogs in the pot and bring it to a boil as opposed to putting all the frogs in the boiling water. So I thought you'd appreciate that, Evan. But nevertheless, yeah. So I hear what you're saying. It sounds like, Ashley, that I don't think anybody's vocalizing a vote for a mandatory registration process.
Yeah, I haven't heard that. So I just wanted to make sure that if anybody did have that feeling, that they had an opportunity to share that with us. So Alan, by the way, good to see you. I saw that you joined us. Glad you're here.
I apologize. I was late. I had a kind of emergency child custody situation for a client. Sorry.
No problem at all. No problem.
Involving weapons.
So hearing no advocates, and I'm certainly not an advocate for a mandatory system, but just hearing no advocates. So I think then we appear to have consensus that we think we should be looking at an educational or a voluntary program. And then we've got some different ideas about what that might look like. And that we might want to do some surveying, we might want to do some CLEs. And, we talked at the last meeting for an idea that I really liked, which is sort of creating an easy to use Google form or whatever that can go into the State Bar database that someone can fill out indicating who their successor is. And there can be a lot of different ways to encourage that without a CLE incentive. So Brian, from your perspective then, what is the next step?
So I think there's, if we are, it sounds like we're kind of looking at, like you said, voluntary and education. And maybe the question is, is there room for both? Is there one that you prioritize first? And it based on kind of the content of the conversation so far, I feel like I'm hearing a lot of interest in educating folks first, which of course, the voluntary designation, it's something that really, that's an opportunity that the bar can create. But then you have to educate folks on its existence and its purpose to really motivate folks. So the education piece, I think that's where it can, if we're focusing on educating folks just on the topic itself and equipping people, maybe that's kind of a part of it. It's one thing to say this is important. It's another thing to say, and this is how you fix it, or this is how you can improve your situation. And to that end, I don't know if anybody clicked through any of the succession planning links, the handbooks that I provided in the materials. That could be something that we all take a look at. I'll tell you, I've got them open on my screen. They are long. There are some that you'll probably look through and say, my goodness, they went into some great detail here, but maybe even too much detail. But they have stuff like checklists, and this is the question of what would be a part of an educating or an educational sort of movement? Would we be looking to educate folks on the importance of the issue? Are we trying to equip them with templates, with checklists, with all the different things that you would need to think about when organizing your office and kind of planning for somebody else to step into your office? Can
I interrupt you there, Brian? Do you mind if I just stop you there? I suspect we all think we need some type of educational material like that. Is that true? Can you guys shake your head if you think that's right? And I'm sorry to interrupt you, Brian, but I think I'm hearing you on that. And I think that if the staff would like to put together what you think would be most helpful for members of the state bar, either as the format to use, and then if y'all think we need some educational materials to go with it, we can look at that, or we can put together a subcommittee of this group, the subcommittee, a small group of us, to help with the preparation of those materials. And then, because I think you've got to have some materials before you start doing training.
Yeah, I think you're right. We can absolutely do that. Just have and this is something that Barry, you and I can work on. Barry and even Savannah has worked with the trustee process. I did that back in my former life in the Office of Counsel. So it's something that I think from that perspective, you see the end result and you see what was needed to make this situation better. And so we can kind of put our heads together just to kind of, I think, sketch kind of an outline of what it is. Maybe not actually create the actual forms, although I have to say the trustee handbook has a number of forms that I think can be borrowed from as well. So we'll put our heads together to see if we can create a sketch and share that with this subcommittee. And if the subcommittee has input, well, what about this, so forth, we can kind of get those materials together and then talk about really I feel like the CLE, if there's a potential CLE or some sort of presentation, that's the kind of the publicity part of this, to really spread the information and its availability to the masses. And that is probably a second step. The materials are first. So we'll take that on and try to report back to her.
Brian, let me interrupt, and I see Dion's got her hand up too, but I think we can run both tracks at once. We had discussed earlier that this could sort of be like a quasi PMBR situation where we've got enough resources to draw upon to create, a checklist that we can prepare, and I think fairly easily, and send it out with this survey that I was talking about. But I think the educational side starts with, with Marcy, with the letter and some other information that goes out, and this committee, if it turns into sort of a PMBR like committee that's looking to prepare some stuff, that we reach out to the North Carolina Bar Association and partner with them. We reach out with the North Carolina Academy or Advocates for Justice, partner with them, and Lawyers Mutual. Somebody from Lawyers Mutual ought to be on this subcommittee, since they see this a lot. And I know Barry sees it a lot too with his work, especially. God knows you've got a full plate, Barry, with all the stuff you do. But I think we can run both tracks at once, because I think we need to sort of roll out on a steady basis the educational materials as best we can, and then work here to create a PMBR like structure.
I appreciate that. Oh, sorry.
Yeah, I think, Dion, did you have your hand up? Did you have a comment you wanted to make?
Yes, just very quickly. I do think this would be a really great program to take on a local level if there is a road show of some sort that could be developed. for a couple of reasons. Number one, the local bar would be interested in getting, easy CLE. Secondly, it puts us all in place where what a great time to ask someone to be your trustee because you have someone there. I think a lot of people get a little shy or either get a little, that's a tomorrow problem. That's something I can ask somebody about tomorrow. Where if we get all together and we're all sort of thinking and talking and we're local and we have our people in place that would make a good match, it may be a good time that program in and of itself would create the opportunity to meet who you would want to be your trustee. So those are just, I do think on a local level, rolling this thing out is where we're going to get people to listen and to actually do something about a succession plan rather than just, hearing it from the top down in the great big world of the state bar.
Barry?
Yeah, to piggyback on what Eben and Dion just talked about, educational wise, as it so happens, the Senior Lawyers Division of the North Carolina Bar Association is meeting starting this Friday. And so I reached out to Alice, and with her blessing and Catherine's blessing, I reached out to the committee about maybe getting on their program for Friday. And sure enough, they have gotten back with me this morning and said I can speak to them on Friday morning about this. And that my intent would be to get some feedback from them about this program that I could come relay back to the subcommittee on this. So this will be about
Barry.
Just introducing them to the fact that the subcommittee is addressing this currently, and we'd appreciate their feedback and their input on what we can do, what should be done, especially for our senior lawyers that are. Hopefully, I'll have a captive audience.
Thank you for doing that, Catherine G.
Yes, ma'am. Thank you. Another thing that we could talk about is Fred Morlock. For those of you who got to see Fred's presentation at the council meeting, saw that he's a pretty passionate advocate for serving as a trustee. And he is willing to go to district bar meetings and advocate this, and also to prepare a video that we can put on our website. And also, I'm sure he'd be willing to have that be shared with Lawyers Mutual and anybody else who would show it, so that he can get the word out about why this is a rewarding thing to do. I might be naive, but I do think that most lawyers just don't think about this, and that most lawyers I know want to do right by their clients, and that's why they're lawyers in the first place. And if they gave some thought to the fact that their clients are imperiled if they don't make these succession plans, and to the fact that their estates would be liable for the costs that would be incurred to unravel this, which can be considerable if your office is in a big mess, that we probably we're not going to get 100% buy-in, but I think we would get more people doing this. And if we get more people doing it, then it's a benefit. So I'm a big fan of the idea of education, and particularly what Barry's doing, going to a group that is inherently affected by these issues and speaking with them. I think a lot of them will say, I hadn't really thought about that, but I've done my estate planning for my family. I've, taken care of all that, but this is a part of that. So I would encourage you to think about maybe using Fred's video that he's going to make broadly, and we can certainly put together CLEs. I love the idea of having a CLE that we could offer for free, but that you don't get credit for it until you actually take some steps that we can measure. So.
Thank you. I think that's great. And, with the CLE, with the sort of little practical piece, you could always you could do a 50-minute CLE and the presenter leave the last 10 minutes for you to, go online to whatever tool we develop or whatever's in the materials to do their plan. So it could be done that way too. And I just want to say too, I thought Savannah did such a great job presenting to the state bar. I think she would be a good presenter as well. Brian?
I just wanted to ask a clarifying question. We were talking about creating materials, and to the extent that that this is helpful, I wanted to be sure that we're all aware. The I'm going to share my screen here. The Bar Association has a ebook on retiring or resetting, reinvent all this stuff, but closing the practice that I think is quite helpful. And it has stuff like, this is your initial checklist for protecting client interests and closing the law office in an orderly manner. It has different tips and suggestions. Having this up-to-date office procedure about where your client ledgers are kept, how the open active files are organized, things of that nature. And I guess my point is that, rather than reinventing the wheel, if there's existing resources that we actually really appreciate and we think they're appropriate for the bar here in North Carolina, then our focus could perhaps be just as much, if not more so, on spreading the message, starting the conversation, like Dion said, actually getting people to think about it. I think we all realize that these conversations need to be put in the forefront of our minds, the way that Barry's going to be doing on Friday. And so I think maybe one request, I'm going to put a link to this resource in our chat, and maybe I'll email it to you all. That way you'll just have it in your inbox. And I would ask if everybody could take a look at that and just see, what do you think of that sort of resource? Is that covering everything? What's missing? I'm going to look through it ourselves, and still, we can put something together of kind of from our perspective, from the ethical state bar perspective, what should a resource have? And maybe there are existing resources that we can then just direct people to, as opposed to recreating, but then also fill in some holes where we see them. And then we can focus more on the message, if that's okay with you.
I think that sounds great. And I'm seeing a lot of heads nodding. So I think we've got one more minute. So I think I'll just sort of summarize what we've done. I think we've made really good progress today because we decided we don't want a mandatory program in North Carolina. We want to educate folks about it and start to get them to thinking about doing this, because we kind of all agree folks just aren't thinking about it. We want to put together some CLE and use some folks like Fred or Savannah or other people. We all agree that a local approach is a good approach, but also a state, Marcy showing leadership around this and maybe some of her bar articles. And then I'll work with Brian to kind of firm up anything we want to do around materials. And Brian, do we think we want to have one more meeting before July, or do we need that, maybe another meeting before July, so that we can report out or make a recommendation to the committee?
Yeah, I think a good thing. Well, let's we'll reconvene. You and I can speak about just what we need to go out with the next step, how much time staff will need in between meetings to have something substantive to discuss. But I certainly think we're meeting early enough in the quarter that we could try to reconvene, say the end of June, something like that. But we'll let everybody know as soon as we get those plans firmed.
So we'll either reconvene or send an update sort of with where we are for purposes of preparing for July.
Yes.
Thank you, everybody, for really good feedback. I think we've done good work today. Brian, thank you so much as always.